Missouri's newest gun law may be unconstitutional.
Missouri Governor Mike Parson is defending a controversial new Missouri gun law that's caused confusion among law enforcement.
The state administration convinced lower courts that Missouri's Second Amendment Preservation Act violates the U.S. Constitution.
I mean, the red flag laws have never been in place in Missouri. You know, you're still talking about somebody with a mental illness.
I will protect the Constitution, which includes defending Missourians' fundamental rights to bear arms.
I've been a law-abiding citizen all my life. I am going to support people to have weapons that are law-abiding citizens.
The United States Supreme Court just refused to revive Missouri's Second Amendment Preservation Act. They denied certiorari, meaning they declined to even hear the case. The vote was 8-1, with only Justice Clarence Thomas dissenting and wanting to take it up. Missouri's original attempt to block state and local police from enforcing federal gun laws is now effectively dead. But here's the thing, nobody is telling you Missouri isn't done. Not even close. Republican lawmakers in Jefferson City are already pushing a new version of this law. The fight over whether your state can protect your rights from federal overreach is far from over. I'm going to break down exactly what this means for you, what went wrong with the original law, and what's coming next.
Missouri Governor Mike Parson is defending a controversial new Missouri gun law that's caused confusion among law enforcement.
Missouri's newest gun law may be unconstitutional.
America Tonight, a bipartisan group of senators say they've reached a framework on gun legislation.
The Supreme Court rejected Missouri's bid to revive its law aimed at declaring various federal gun restrictions.
Look, I don't think anybody wanted to hamper or should be hampering law enforcement from working together with federal agencies or state agencies.
All right, so let me explain why this matters to you personally, even if you don't live in Missouri. This case, Missouri v. United States, was the single most aggressive attempt by any state in modern American history to nullify federal firearms regulations within its borders. If the Supreme Court had taken this case and sided with Missouri, it would have opened the door for every single red state in the country to pass similar legislation. Your state could have told the ATF, told the FBI, told every federal agency that their gun regulations don't apply within state lines. That door just got slammed shut, at least for now. And if you're a gun owner in Missouri specifically, you need to understand that the $50,000 penalty that would have been imposed on any local officer who enforced federal gun laws, that's gone. Federal firearms enforcement in Missouri is fully back on the table. Agencies like the ATF can resume full cooperation with state and local law enforcement without any threat of state-level penalties. That's the reality right now. So let me walk you through how we got here, because the procedural history on this one is critical, and it tells you exactly where the weaknesses were. Missouri passed the Second Amendment Preservation Act, known as SAPA, back in 2021. Then Governor Mike Parson, a Republican, signed it into law at a Kansas City gun shop called Frontier Justice in June of that year. The law itself was sweeping. It declared that virtually all federal acts, laws, orders, rules, and regulations that infringe on the right to keep and bear arms would be considered invalid within Missouri's borders. We're talking about federal registration and tracking requirements for firearms, accessories, and ammunition. We're talking about restrictions on possession by certain prohibited persons. We're talking about any tax, levy, fee, or stamp imposed on firearms beyond standard sales tax.
The Justice Department says that Missouri's new law prohibits local authorities from enforcing federal gun laws.
Missouri law enforcement could be fined for enforcing federal gun laws that conflict with Missouri law.
The state administration convinced lower courts that Missouri's Second Amendment Preservation Act violates the U.S. Constitution.
A group of 20 senators, evenly gathered from both parties, say they hope to have the bill passed sometime.
The law went further than just non-cooperation. It imposed a $50,000 civil fine on any public officer or employee of the state who knowingly enforced these federal provisions. That's the part that made this different from a sanctuary city policy. Sanctuary cities simply declined to assist federal immigration enforcement. Missouri wasn't just declining to help, it was actively punishing anyone who cooperated with federal authorities on firearms matters. The Biden administration sued Missouri in 2022, arguing the law was unconstitutional. The case landed in front of United States District Judge Brian Wimes, who ruled in 2023 that SAPA violated the Supremacy Clause of the United States Constitution. That's Article 6, Clause 2, which establishes that federal law is the supreme law of the land when there's a direct conflict with state law. Judge Wimes didn't mince words. He wrote that the Missouri statute was an unconstitutional violation of federal law and was, quote, designed to be just that. Missouri appealed to the United States Court of Appeals for the Eighth Circuit, and the Eighth Circuit sided with the federal government, finding SAPA unconstitutional. Former Missouri Attorney General Andrew Bailey then petitioned the Supreme Court not once but twice. The justices first refused to intervene back in 2023, keeping the law blocked while litigation continued. And now, on Monday, October 6, 2025, they denied certiorari for the final time, 8-1.
A federal judge rules Missouri's Second Amendment Preservation Act rules it's unconstitutional.
The Second Amendment Preservation Act is meant to prevent the federal government from
these shootings in Columbia. That's preventing us from getting the help we need at the federal level from stopping all these local shootings.
He signed the Second Amendment Preservation Act into law this weekend. He says it protects gun owners from overreach and executive orders.
Here's what you need to understand about the real-world damage this law caused before it was struck down. The conflict between SAPA and federal enforcement didn't just create a legal headache, it wrecked actual law enforcement operations on the ground. Missouri State Crime Lab refused to process evidence that would have supported federal firearms prosecutions. Think about that for a second. Violent crime cases, cases involving illegal possession, cases that could have taken dangerous people off the streets, stalled because the state lab wouldn't touch evidence connected to federal gun charges. A coalition of Missouri law enforcement officials publicly warned during the last legislative session that SAPA was, in their words, anti-law enforcement and that it harmed their ability to seize weapons from criminals. Kansas City and St. Louis both fought the law from the moment it was signed. And here's a detail that should make everyone pause. At least one of the weapons used during the 2024 Super Bowl shooting at Kansas City's Union Station was purchased at the same gun shop, where Governor Parson signed SAPA into law.
Governor Mike Parson was standing on the opposite side of the stage Wednesday when shots rang out at the Chiefs' Super Bowl rally.
These people, juvenile or not, need to be held accountable. If you're going to do something like that, you need to be certified as an adult. But the reality of it is you can't control people like that when they're going to do bad things. And I just don't believe Missourians are going to go down that road of not giving up their guns.
Now let me give you the broader constitutional context, because this doesn't exist in a vacuum. The doctrine that Missouri was relying on is called nullification, the idea that a state can declare a federal law unconstitutional and refuse to recognize it. This theory goes all the way back to 1798, when Thomas Jefferson and James Madison drafted the Kentucky and Virginia resolutions to oppose the Alien and Sedition Acts. But nullification has been rejected by the courts over and over again throughout American history. South Carolina tried it in 1832 with the nullification crisis over federal tariffs. Southern states tried it again during the Civil Rights era to resist desegregation. Every single time, the federal courts have said no. Missouri's SAPA was the most sophisticated modern attempt at nullification we've seen, but the legal outcome was entirely predictable.
It comes as the police department is suing his administration to overturn the Second Amendment Preservation Act.
Police are suing now, clashing with Parson over their power to enforce federal gun laws here.
I mean, the red flag laws have never been in place in Missouri. You know, you're still talking about somebody with a mental illness. I've been a law-abiding citizen all my life. I am going to support people to have weapons that are law-abiding citizens.
What's important is how this intersects with the current Second Amendment framework coming out of the Supreme Court. In 2022, the court decided New York State Rifle and Pistol Association v. Bruin, which established that gun regulations must be consistent with the historical tradition of firearms regulation in the United States. Then in 2024, the court decided United States v. Rahimi, upholding the federal prohibition on firearms possession by individuals subject to domestic violence restraining orders. That was an 8-1 decision as well, with Chief Justice John Roberts writing for the majority that Second Amendment precedents were, quote, not meant to suggest a law trapped in amber. Roberts emphasized that courts must determine whether a new law is relevantly similar to laws that historical tradition permits. This matters because SAPA specifically targeted the federal domestic violence prohibition as one of the laws Missouri wouldn't enforce. The Supreme Court has now said twice, once in Rahimi and now by refusing to hear Missouri v. United States, that these federal restrictions stand.
She was going to come to your house on your front door and take it away. Well, not in Missouri, she's not.
I will protect the Constitution, which includes defending Missourians' fundamental rights to bear arms.
The Second Amendment Preservation Act is currently being challenged in court because some Missouri counties say it's unconstitutional.
There have been a handful of bills filed by Democrats this legislative session asking for stricter gun laws.
So let me give you the honest assessment. Is this a total loss for Second Amendment advocates? No, it's not. But it's a serious setback for anyone who believes state-level nullification was a viable strategy for protecting your rights. The anti-commandeering doctrine, the principle that the federal government can't force state officials to enforce federal law, that still stands. The Supreme Court affirmed it in Prince v. United States back in 1997 and in Murphy v. NCAA in 2018. States absolutely can decline to use their resources to help enforce federal regulations. What they cannot do is declare federal law invalid within their borders and punish people for cooperating with federal authorities. That's where Missouri crossed the line, and that's why every court that looked at this said it was unconstitutional. Now here's what's coming next, and this is what you need to watch. Republican Representative Bill Hardwick from Dixon, Missouri, has been sponsoring a new version of this legislation. The details of the revised bill are still being worked out, but the goal is to draft something that stays on the right side of the anti-commandeering doctrine without crossing into nullification territory. Think of it as SAPA 2.0, a law that says Missouri will not voluntarily assist with federal firearms enforcement, but doesn't impose penalties on officers and doesn't declare federal law void. Whether that version can survive judicial review depends entirely on how carefully it's drafted. The Trump administration, interestingly, took a split position on this case. They defended the prior administration's authority to sue Missouri in the first place, maintaining that the federal government can challenge states that claim to invalidate federal statutes. But they also said they no longer wish to challenge Missouri's law before it was enforced in a real dispute and suggested narrowing the lower court ruling. That's a signal that the current DOJ may not aggressively oppose a more carefully written version. Here's your status check right now. Missouri's original SAPA is dead. Federal firearms laws are fully enforceable in Missouri with state and local cooperation. The $50,000 penalty against officers is gone. If you're a gun owner in Missouri, nothing changes about what you can legally own or possess. This was always about enforcement mechanisms, not your individual rights. But keep your eyes on Jefferson City. A new bill is coming, and depending on how it's written, it could reshape how your state interacts with federal gun enforcement going forward. I'll cover it the moment we have bill text. That's it for today, folks. See you in the next video.